Okay, I think it's 12:01, so we're good to get started. First of all, welcome everyone to Rudder Law's webinar. How appropriate is it that we are doing a webinar about COVID on Groundhog Day? I should say welcome to Rudder Law's first ever webinar, which is probably going to shock a lot of people who are used to seeing us on the small screen. We have done hundreds of webinars for different organizations over the years, and especially the last 2 years, but always with someone else running the show. So we made the decision a few months ago to put on our own webinar. People that know us know that we pride ourselves not only on advising and advocating on behalf of our clients, but also on educating. So doing things like webinars, seminars back in the old days, our social media, my book Fire Away. My book You're Fired. Fire Away is our online show that we do once a month. And now Rudder Law webinars, which we are very excited about. I can mention that back when COVID started, almost 2 years ago now, we rushed to put some information up on our website because we realized that people were just struggling with how to deal with these new and novel issues that arose. And we created a COVID-19 resource page that is on our website. We hoped it would be short-lived, but it's coming up on the 2-year anniversary, and we continue to update it pretty regularly, although not as often as it was back in March and April and May of 2020. But I do encourage you to take a look at that. I'll mention that when we decided to do a webinar back late 2021, we deliberately held off on announcing a topic because we just had no idea what things were going to look like in early 2022. And honestly, we were really hoping that we would not have to be talking about COVID workplace issues anymore, which looked pretty good back in November. Things seemed pretty promising, and then we seem to have done a 180. And now, of course, we've got new variations and more restrictions and issues like vaccine mandates and testing, bringing employees back to the workplace, et cetera, et cetera. And we reluctantly recognized that COVID-19 workplace issues are still the issue that people need help with. So we decided to do an update on COVID-19 workplace issues as the topic, and that's what we're going to be discussing today over the next hour, or I guess 57 minutes now. So a couple of housekeeping issues, and then we'll get right to it. One is that we do want to be respectful of everyone's time. So we are going to cap this at 1 hour. We'll be finishing at 1 o'clock. Like most webinars, everyone will be on mute. If you do have questions, feel free to put them into the Q&A box. We will try to answer them as we go by typing in answers. So keep an eye on there if you have put a question in there. If we have time at the end, which frankly we may or may not, given the amount of material we hope to cover, but if we have time, we'll try to answer a couple of questions at the end verbally. But if we don't get to your question, or if you have issues that we can help with, then please feel free to reach out to us. And as you've heard many times before, this webinar does not replace legal advice. The Q&A box does not replace customized advice tailored to your specific situation. So feel free to reach out. And many of you guys have heard me say this before. If you think you might need an employment lawyer, you probably do. We'd be very happy to talk to you about how we can help you, especially or ideally before you do something that might compromise your legal position as opposed to after. Other housekeeping points: the slide deck, we're very happy to share it with you, so feel free to reach out. And I keep saying feel free to reach out. There are innumerable ways to do that, but the easiest is probably by sending an email to info@rudnerlaw.ca. You can also email me directly. You can use our social media. You can pick up the phone and call. One way or another, we'll be happy to talk to you. So if you want the slide deck, by all means, let us know. This is being recorded. So the recording should be up on our YouTube channel and probably other places as well within a couple of days. And those are really all the housekeeping matters I wanted to get to. So if I can adjust my windows here, I can move us along in these slides. I've already covered most of the material in this disclaimer, so it does not replace legal advice. And because things keep changing so often, I will emphasize the fact that everything we say today is current as of today, and it may not be current a week or 2 or 10 from now. So be mindful of that as well. Things are changing very, very quickly. In terms of the plan for today, as I said, we're talking about COVID-19 workplace issues. That includes policies. We are spending a lot of our time advising our clients on COVID policies, vaccine policies, etc. IDEL, will it ever end? We'll talk about that. new government assistance, because we've gone through many different phases of government assistance over the last 23 or so months. I get the chance to talk about just cause for termination, which I always enjoy, so we can talk about whether you can fire somebody for refusing to be vaccinated. And then we're also going to talk about other case law developments that relate in one way or another to COVID. So that's the plan for today, and we're going to do our best to cover that in as much detail as possible, starting with policies to consider. So I will turn things over to Brittany Taylor.
Thanks, Stuart, and thanks everybody for joining us today. I'm going to apologize in advance for how quickly I'm going to speak, just because we have a lot of material to get through. So obviously, COVID-19 has created a lot of novel issues for both employers and employees. One of the biggest questions that people have had since this whole thing started is, how can I keep my workers safe without shutting down my business entirely, if at all possible? And that's a question that we are still getting today, even all of these many, many months later. The reality is that creating and implementing workplace policies is actually one of the best ways that employers can take action to try to address this question and address this issue. Now, in some cases, there are policies that are legally required, and I will talk about those briefly. But employers should also keep in mind that they are mostly free to create their own policies that govern the workplace as well. When it comes to COVID-19, there's three main subject areas or topic areas that have been kind of forming the basis of new policies over the last year or so. One includes vaccination policies, which may include vaccine mandates, isolation or quarantine policies. So basically, what is the procedure if someone may have been exposed or is showing symptoms? And COVID-19 testing policies. When, if ever, is testing going to be required? What kind of testing is sufficient? Who's paying for the testing? Where is it being done? All of those issues. Now, I'm not saying that these are three distinct policies that everyone has. A lot of the times this is combined into one big COVID-19 policy, or a COVID policy and a vaccination policy. In terms of required policies, I just want to touch on this really briefly, which is that all businesses that are currently open in Ontario are still required to have a COVID-19 safety plan in place. Now, the government of Ontario has prepared a very detailed guide to developing your COVID-19 safety plan, and that includes a free plan builder tool, which is available online. So if you have not yet done your safety plan, or you're not sure if it's up to date, I strongly encourage you to take a look at that resource. The other thing that may be required, depending on where you are operating, is a vaccination policy. So certain jurisdictions, like in Toronto and Peel, where there's been express recommendations that we have these policies, it's probably in your best interest to make sure that you do have one. Now, this does not mean you have to mandate vaccination. It just means you have to have a vaccination policy. So let's talk a little bit more about that. So Stuart, if you don't mind going to the next slide, please. Okay, so what is a vaccine mandate? What are we talking about here? So this is essentially a requirement that is being imposed on your staff that they be vaccinated in order to do something related to their job. Now, this could be as broad as you must be vaccinated in order to work for our company at all, or it could be more narrow, such as you have to be vaccinated if you want to come into the office. Now, a lot of employers are panicking or have panicked at the idea of imposing a vaccine mandate. But the reality is that a lot of the vaccination policies that are being drafted right now are not actually mandatory vaccination policies. They are policies that require vaccination in certain circumstances with certain groups of employees, or they may provide employees with an option of either getting vaccinated or being tested. What will be necessary in one business could be very different from another. So as a result, if you're going to take one piece of advice away from this, don't just download a policy off of Google and apply it to your workplace. These are not one size fits all policies. They really do need to be customized depending on your specific workplace. Now, there's a lot of potential risk out there for employers in either failing to have a policy or not enacting an appropriate policy in the workplace. So obviously failing to have one could lead to increased safety risks in the workplace. Other concerns about not having an appropriate policy include things like the potential for constructive dismissal claims for workers who are suddenly subject to these new restrictions. You could have understaffing due to an unreasonable restriction or unreasonable policy. The other issue, of course, is what do we owe employees if we decide that we do want to part ways because they're not being vaccinated? And Stuart, of course, is going to talk more about that as our just cause expert later on in our presentation. So let's move on to the next slide. Okay, Vaccine mandate options. So as I kind of mentioned, employers effectively have two options when it comes to a vaccine mandate. They've got the vaccinate or dismissal option, which is every employee or every employee in certain categories have to be vaccinated by a certain date, and they have to provide proof of vaccination. If they don't do that, they're usually placed on some type of unpaid suspension, ultimately leading to dismissal if they still refuse to comply with the policy. Option two, and probably the more common type of policy that we see, is a vaccinate or test policy. This basically gives employees the choice of either getting vaccinated and showing proof of vaccination or agreeing to frequent testing. Any employee who refuses both options, again, we tend to see that unpaid suspension or leave, usually followed by dismissal at a certain point. Now, which of these vaccine mandates or any vaccine mandate, whether or not it's going to suit your business, again, is very context specific. Now, what you have to understand is that when you are imposing a vaccine mandate of any kind, you are infringing on an employee's rights in several different areas. Now, this includes their right potentially to be free from discrimination and their privacy rights. In order to justify that infringement, you have to show that there's a lack of alternatives. In other words, why is it necessary to have this policy? We're going to talk a little bit more about that on the next slide. So, vaccine mandates, institutional considerations. Basically, this is the question of what type of vaccine policy should I implement? How do I figure out what's appropriate for my business? The real question that you're asking here are, what are the safety risks or requirements in my specific workplace, and how can I address them by infringing as little as possible as I can on employee rights? So there's a couple of different questions that you can ask yourself in order to assess what kind of policy that you need. So consider the type of work that's being performed. Does it have to be done in person? Can it be done remotely, for example? Also think about, what is your workplace setup like? Do workers always work in close proximity? Are they interacting directly with the public? Is there a way to keep people separate and apart? The other thing is, are there any third parties imposing demands on your workplace? So, for example, do your workers need to go on a construction site that is subject to a vaccine mandate? And if they don't go on the site, they can't do their job. These considerations are all vital in terms of assessing what the right policy is for you. And on the next slide, we're going to talk about how you balance employee rights with your obligations as an employer. Now, when we're talking about your obligations as an employer or an employer's obligations, we're talking about the Occupational Health and Safety Act, which imposes a requirement on all employers to take reasonable steps to ensure a safe workplace for their staff. This includes ensuring that your workplace does not become a super spreader event. When we're talking about employee rights, as I mentioned before, we're talking about things like their right to be free from discrimination. We're also talking about their right to privacy, including privacy over their personal health information, right? Any policy, again, that you implement needs to take this balancing of your obligation and these rights into consideration. And when I say take it into consideration, I don't mean think about it and then make a decision. I do mean that, but more than that, I mean note it specifically in your policy. There should be a section in your policy that talks about accommodation. There should be a section dealing with how private information is going to be protected, how confidentiality is going to be maintained to the greatest extent possible. So let's turn now to one of those rights that we're talking about, which is human rights. One of the questions that we get most frequently right now is, what if one of my employees refuses to be vaccinated? Now, we know that there are circumstances where an individual may be unable to be vaccinated due to their membership in a protected group, such as somebody who has a disability or a religious belief that would prevent them from getting vaccinated. This is very different than choosing not to be vaccinated. And there's a great quote I really like here, which is, are you a person who objects to vaccination and happens to be a member of a religious group, or are you a person that is a member of a religious group that objects to vaccination? So essentially, the whole point of that quote is to say that someone's personal belief about vaccinations is not a protected ground under the law. It does not constitute creed, which is one of those protected groups. Now, the Ontario Human Rights Commission has released a statement confirming that this is the case, which was a big relief for employers out there. So if you are an employer and you receive a request from an employee saying, I don't want to be vaccinated or I can't be vaccinated, how do you assess the legitimacy of that exemption request? As an employer, you are entitled to documentation that supports someone's request for an exemption. So that could include a medical note if they're suffering from a disability that prevents them from being vaccinated. In terms of creed or religious exemption, it's a bit more difficult. A lot of what we've seen is personal statements from employees, often with a letter from their priest or spiritual advisor confirming that the vaccine would violate their religious beliefs. If there is no legitimate need for an exemption, in other words, a code protected need for exemption, then they're not entitled to accommodation under human rights. If there is a legitimate exemption to getting a vaccine, the duty to accommodate is triggered. Now, we could do a whole presentation on the duty to accommodate in this specific context. For now, I'm just going to leave it by saying that this is something that employers do need to take seriously. However, it's not hopeless. Accommodation is not unlimited. Your duty to accommodate only goes up to the point of undue hardship. So if there is no way to accommodate an employee without creating significant safety risk for someone else, or in a way that allows this person to still do their job, you may reach this threshold. Okay, next I'm going to touch really quickly on privacy rights. So just in general, an employer is typically not allowed to have access to an employee's private health information. An employee's vaccination status or their record of vaccination would fall within this heading of private health information. But this is one of those examples where the employer's obligation to ensure a safe working environment trumps or infringes in an acceptable way on an employee's privacy rights. We know that an employer is entitled to know whether an employee is vaccinated or not. We have an arbitration decision, which basically flat out says a vaccine mandate is completely meaningless without the requirement for employees to disclose their vaccination status. So employers are entitled to understand whether an employee has been vaccinated or not so that they can manage safety in the workplace. What is really crucial in terms of collecting this information, though, is how you are storing it, who has access to it, how is it being used. And again, this is something that should be expressly addressed in your policy. The long and short of it is that this information should be kept as secure as possible with as few people having access to it as possible. Okay, what does the case law say about policies in terms of vaccination mandates? So to date, we actually don't have any court decisions regarding the enforceability of a vaccine mandate. But that doesn't mean we don't have any direction, because we actually have several arbitration decisions on whether a vaccine mandate is going to be upheld or not. Now, I'm going to give you a spoiler. It's right here on the slide. None of these cases say that refusing to comply with a vaccine mandate or a vaccine policy constitutes just cause for dismissal. They do not say that. So we're going to say, just get that out of the way right now. So let's talk about what these cases do say. So the first thing to understand is what is the facts? Like what is this case arising in the context of? And the facts are very similar in all of these cases. Essentially what you have is an employer introducing a vaccine mandate. The union grieves that policy, alleging that it is unreasonable or unlawful in some way, right? Those are the basic facts. The results that we get from these decisions is more policies being upheld than policies being struck. In fact, we so far only have one policy that's been struck out. So I'm going to talk about three cases specifically. I'm just going to give you really quick background because, again, context is really crucial and important in this case. So the first case that we're dealing with is involving a security company, Paragon. They introduced a vaccination policy requiring vaccination for all employees by a set date. Again, this is a security company employing about 4,000 security guards at 450 different client sites. Now, the majority of these sites had their own vaccination requirements. In addition, in this case, the collective agreement between the parties already contemplated that employees could be required to be vaccinated if there was a site mandate requiring that. They either had to be vaccinated or be reassigned. So there was already a contemplation of that issue in the collective agreement. Another context, Ontario Power Generation is another employer who had their policy challenged. They introduced what I would like to call a vaccinate or test policy that I referred to earlier. So employees could either go get vaccinated and show proof of vaccination or undergo testing twice a week at the employee's cost. And if they were refused, they'd be placed on an unpaid leave and eventually terminated for cause. The final one I want to talk about is Electrical Safety Authority was the employer in this case. They implemented a mandatory vaccination policy that required everyone to get vaccinated. And if they didn't, they could be placed on an unpaid leave or subject to dismissal up to and including termination. Now, what's really key about this situation is that the vast majority of the work that was being undertaken by employees was being done remotely and could be done remotely. And remote work was actually contemplated as a right that employees had in the collective agreement.
Sorry to cut you off, but I have to give you a 30-second warning at this point.
I'm almost done, I
Oh,
swear.
and I'll just remind everyone, I noticed a few questions popping up in the chat box, so please put your questions in the Q&A box.
Thanks, Stuart. Okay, so as I said, in this case, in with these cases, we've got more being upheld than not. So we've got 2 being upheld, 1 not. Paragon and OPG, their policies were fine. They struck the appropriate balance between the rights of the employee and safety concerns. The only adjustment made to the OPG policy, which I think is important for employers to be aware of, is that the arbitrator did say that OPG was required to cover the cost of the employee testing, but they could require that employees do it on their own time. Now, Electrical Safety Authority was the unlucky employer in this case who had their policy deemed to be unreasonable. But the key thing here is the context, right? The arbitrator really stressed in this case that these workers are mostly working remotely. There was no need for such a ridiculously stringent vaccination policy. So this might be a really cautionary tale for employers of making sure your policy actually fits your needs. Okay, I'm going to turn it over to Nadia now, who's going to start us off with a discussion about what employers can do in situations where employees breach COVID-19 protocols. I'm also going to breathe now.
Thanks, Brittany. So I will now address breach of COVID-19 protocols. Here's what it boils down to. If an employee breaches the employer's COVID-19 rules and are lies during the COVID screening process, then that will likely constitute serious misconduct, which can lead to discipline up to and including termination for cause. So in the MLSE case, the grievance alleged that the employer violated the collective agreement and any relevant statutes by placing the employee on an unpaid leave of absence due to undisclosed vaccination status. The arbitrator found it reasonable for the employer to place the employee on an unpaid leave of absence due to their failure to disclose their vaccine status. In the Johnson case, the employee's dishonesty during the COVID screening was found to justify dismissal for cause because the employee engaged in multiple serious violations of the hospital's COVID policies and placed coworkers, patients, and the public at serious risk in a hospital environment where such protections are critical. So while this is good news for employers, every case will be assessed based on the particular factors and context. So we recommend seeking legal advice prior to dismissing for cause. So Stuart, could you please move to the next slide? Thank you. So what are the key takeaways on how to approach COVID policies? First, employers should carefully consider the level of risk that is present in the workplace before implementing a mandatory vaccination policies. Second, the case law shows that there's no one-size-fits-all answer when it comes to the enforceability of vaccination policies. Rather, as arbitrator John Stout emphasized in the Electrical Safety Authority decision, context is extremely important when assessing the reasonableness of the rule or policy. For example, in workplaces where higher risks are present, such as where employees work with vulnerable populations, mandatory vaccination policies may not only be reasonable, but necessary in order to ensure health and safety. The same is not going to be true in a workplace where, let's say, the majority of workers are able to work remotely and where there is no significant risk of a potential outbreak. Third, employers should consider whether there are less intrusive alternatives available and whether there is a need for accommodation. Consider the options for accommodation, such as allowing employees to work remotely or requiring regular mandatory testing for employees who are not vaccinated. Finally, if an employee is dishonest or breaches a policy, then that may justify discipline up to and including dismissal for cause. The key word here is may, and that's because Just cause for dismissal has a very high threshold, and we strongly recommend, again, seeking legal advice before you either impose disciplinary action and or dismissal. So on to the next slide now. Now, what are an employer's obligations to an employee who's unable to attend work due to being exposed to COVID or testing positive with COVID? Does the employer need to tell the employee's colleagues? So employers should be very careful with an employee's private information, as Brittany touched upon. And an employer should breach an employee's privacy rights to the minimum extent possible. This means you should only disclose the information to the extent that is necessary. Another thing to keep in mind is whether to pay the employee while they're in quarantine. The Employment Standards Act now includes a provision for paid sick leave for COVID-19 reasons. This is often referred to as paid IDEL or paid infectious disease emergency leave. And an employee is entitled to up to 3 days off work with pay. The employer must pay the employee for the time off if the employee is eligible, and the employer can recoup at least a portion through the WSIB. On to the next slide. I will now address COVID-19 testing requirements. So can you accommodate an unvaccinated employee by requiring them to show a negative COVID test result before coming to work? This is what would be referred to as a vaccinate or test policy, as Brittany mentioned. Either the employee vaccinates or they're required to undergo regular testing. An arbitration decision ruled that an employer may require an employee to undergo these tests. However, the employer had to pay for it, and the employee had to do the test outside of work hours, as Brittany mentioned. So employers have to keep in mind various considerations, including the availability of tests, as well as what kind of testing is appropriate. For example, PCR or rapid tests. And employers also have to be mindful of privacy considerations, as Brittany mentioned. So on to the next slide. I'm now going to be talking about the logistics of COVID-19 tests. Recently, the logistics of the pandemic have caught up with testing as an alternative. Depending on the context of the workplace, the employer may be required to supply the tests themselves or pay for the tests themselves. When implementing a testing requirement in place of a vaccine mandate, keep in mind that tests may not be accessible. So what happens then? Consider whether there is a need to and whether you can accommodate the employee up to the point of undue hardship. Consider whether remote work is possible and whether you need to place the employee on an unpaid leave of absence in the interim. Now I'm going to talk a little bit about infectious disease emergency leave. So IDEL, or infectious disease emergency leave, is an unpaid job protected leave for employees who cannot do their job due to specified COVID-19 related reasons. For example, for being sick due to COVID. Unpaid IDEL was introduced in May 2020, but it was backdated to March 2020. I already mentioned paid IDEL a couple slides back. Paid IDEL was introduced long after unpaid IDEL. And unpaid IDEL really boils down to this. Employees who have their hours and or their pay reduced due to COVID are not considered to be on a temporary layoff, but rather they're deemed to be on IDEL, or a leave of absence, for the purposes of the Employment Standards Act. On to the next slide. So while IDEL was initially supposed to last for a relatively short period of time, it was extended as the pandemic raged on and is currently scheduled to end at the end of July 2022. This means that after that date, the regular temporary layoff rules under the ESA will resume. I will now pass it on to Jeffrey, who's going to present on the new government supports.
Great, thank you, Nadia. So federal and provincial governments have both taken steps towards providing time off to address COVID-related absences, and just some levels of government have taken the opportunity to enhance access to sick leave in general. So as Nadia has just discussed, Ontario has introduced some aspects of paid sick leave, which is the paid infectious emergency, paid IDEL, let's call it. This is for employees in relation to the COVID-19 pandemic. Where Ontario is unique in relation to the rest of the country so far is that employers who pay for employees' time off can apply to recoup the cost to a certain extent from the WSIB. This is all obviously in place until until IDEL is ended at the end of July, which is currently scheduled to end in July, which of course may be extended. Across the country, we're seeing some mixed results. Federally, Bill C3 has received royal assent, which changes the Canada Labour Code such that all federally regulated employers have to provide employees up to 10 paid sick days a year. It's currently at 5. There's negotiations going on with unions and various other bodies to determine how these 10 days are going to be enacted. Obviously, we will watch our website and watch our blog, and we'll keep everybody updated when this changes. BC, as of January of this year, has 5 paid sick days, and these are for injury or disease altogether. Whereas, as I said, Ontario is primarily and exclusively for COVID stuff, and it's very expansive in Ontario for COVID-related illness reasons. So if an employee has had a negative reaction to the vaccine, they can take the day off, which is quite expansive and quite good. Slide, please, Stuart. In terms of income support, obviously CERB has ended quite some time ago. The quasi-replacement is the Canada Worker Lockdown Benefit, which provides a temporary income support to people who can't work due to a COVID-19 lockdown being declared in their region. The amount is $300 for each 1-week period between October 24th, 2021 and May 7th, 2022. And the lockdown has to have gone on for 14 days. There are currently no regions, as I'm aware, that are under this eligible for lockdown benefit under lockdown. Again, obviously watch our blog as this emerges. We'll keep this posted. It's a quick one slide, please, Stuart. And this is what we're all here for, is in terms of what kind of business rebates we're talking about. So Ontario has introduced 2 major assistances to businesses. One is the Ontario Business Cost Rebate Program. This is backdated to the start of the most recent restrictions, which are December 19th, 2021. It gives eligible businesses rebate payments depending on the extent to which they were required to shut down for the most recent round of the pandemic. So if a business was forced to shut down its capacity by 50%, it can apply for a rebate for property tax and energy costs it had paid up to 50%. Similarly, a business that was forced to close to, say, 100%, like a gym, can apply for a rebate for up to 100%. This is specific to industries, and there's a list of them on the Government of Ontario's website. If you can't track this down, please feel free to reach out to one of us. We will forward you the necessary information. And the other aspect, slide, thank you very much, Stuart, is the interest and penalty-free period. Ontario has introduced a 6-month interest and penalty-free period. So effectively, for any business in Ontario that has a tax return or taxes due between January 1st, 2022 and July 1st, 2022, you will have to submit these by July 2nd. Interest and penalties will not run during this period. It's very generous from my perspective, and it assists business to a large extent. That is it. I will now pass it off to Stuart, who is going to discuss just cause and vaccine mandates.
Cool. Thank you very much, Jeff. So as I promised at the beginning, I get to talk a little bit about this. And in my humble opinion, I think this is going to be one of the very significant legal battlegrounds over the next few months and few years, because nothing happens in a few months, as most of you guys know. So first point, there is no case law dealing with non-unionized workers that has considered the issue of whether refusing to be vaccinated or refusing to produce your vaccination status constitutes just cause for dismissal. There have been a lot of media headlines about arbitral decisions, but those have all been procedural. And basically, those have been situations where a company has sought to implement a vaccination or a vaccine policy, and the union has objected and sought an injunction to prevent them from putting the policy in place. And in most of those situations, the arbitrators have said that the company was within its rights to put those policies in place, sometimes with some minor tweaks. But the point is, the arbitrators have not said that the company does or does not have the right to fire someone for refusing to be vaccinated. That's a question for another day. So we have no case law on this whatsoever. And in my humble opinion, we're not going to get a clear answer. I mean, you've heard a lot of people over the last few months prognosticate on this, and some people have said absolutely employers can and should require that all their employees be vaccinated, and if they don't, they can fire them. And we've had probably an equal number of people say absolutely not. You should never be fired because you refuse to be vaccinated. And I'm going to say something that we haven't actually said in 35 minutes so far, which is that it depends. That's almost always the answer when the question is, can I fire somebody for blank? And it's most certainly going to be the answer here, because the assessment really, in my view, is going to come down to whether the requirement for vaccination is reasonable in the specific circumstances. And that's why it's going to be a very fact-specific analysis. So let me talk about that a bit more over the next couple of minutes. So first of all, taking a step back to first principles. In Canada, there are basically two types of dismissals. There's with cause, which means that the employee is generally not entitled to any notice, termination pay, severance pay, or any other compensation beyond pay for what they've already worked. That's, not surprisingly, and I think Nadia said this earlier, a pretty significant decision, and therefore the threshold is quite high. And I'm going to talk about that more in a moment. That's with cause. The second type is without cause, which is the vast majority of dismissals in Canada. So that could be a downsizing, could be a situation where you just found somebody better, it's just not working out. It's not a cause situation. So in that case, the employee is entitled to notice or severance pay or termination pay. And contrary to what's still a fairly popular belief, there is no near cause. We still have clients saying, well, they weren't such a great employee, so surely they don't get as much severance as a really good employee. And it's all or nothing. You either have just cause or you don't. There's nothing in between. So with that background in mind, as I've said a few times, I've spent way too much of my time reviewing just cause cases. So to give you a sense of how seriously many of our courts take this, it's been referred to as the capital punishment of employment law. Because imagine a long-term employee who might otherwise have a year or a year and a half worth of severance entitlement, but if they're fired for cause, they get nothing. The consequences are quite harsh, and so judges will, there are cases every year where judges do find that there was just cause, but the threshold is high and judges take it quite seriously. And the one thing that a lot of people don't realize is, as this slide indicates, you don't only look at the misconduct in question. So putting this in the context of vaccination, it's not only a question of did they refuse to be vaccinated, and if so, can you fire them? What our courts have always said is you look at the misconduct, and then you look at whether the nature or the degree of the misconduct had warranted dismissal, bearing in mind all the relevant circumstances, which is usually referred to as the contextual approach. So relevant circumstances would include things like how long they've been employed, whether they've been in trouble before, the disciplinary history and the disciplinary warnings that have been given out, as well as things like their response when they're confronted. And that's often a scenario we go through where there might be an investigation because someone is suspected of theft, for example. A, you want to make sure that the employee did engage in theft, but B, you want to confront them, give them a chance to respond, and their response will often be the deciding factor in assessing whether some lesser form of discipline is appropriate or whether you do have just cause to fire them. And remember, when you say that you have just cause, basically what you're saying is that you could not be expected to continue to employ them anymore, that the employment relationship had been irreparably broken and could not be resuscitated, and you did not have the necessary trust to continue to have them in your employ. Proportionality is always a guiding principle. We often say, somewhat glibly, the punishment must fit the crime, but as I've talked about it, for the last few minutes, you don't only look at the crime, you look at all the relevant factors. So that's the background here. So when we apply this to the scenario of an employee who refuses to be vaccinated or refuses to disclose their vaccination status, would it be just cause? So let's think about what this means more technically. If someone refuses to be vaccinated or refuses to disclose, they are basically refusing to comply with a direct order or direct direction, if that's a term, or a policy. So if someone fails to abide by a policy, that's breach of policy, which is usually cause for discipline and potentially dismissal. Similarly, if someone fails to abide by a direct order or a direction, that would be insubordination, which would give rise to discipline and in some cases dismissal. But the question is always going to be whether that policy or whether that direction was reasonable. And if it is, then you can impose discipline. If it's not, you can't. And there have been some interesting cases over the years where people have been disciplined and in some cases fired for refusing to follow direction, and they've challenged it either in court or in a grievance process, and the finding has been that the direction itself was not reasonable. Therefore, they didn't have to follow it. Therefore, firing them for not following it was unjustified at law. So that's the analysis that you're going to have to go through. And this is where we get to it depends. Because in my view, courts and arbitrators are going to look at the specific circumstances of the case. They're going to look at the nature not only of the industry that the company's in, not only of the company as a whole, but of the role of that particular worker to assess whether a vaccination requirement is reasonable. And take the two extremes that I keep referring to over the last few weeks or months now. On one hand, think about a healthcare worker who is working directly and closely with patients who are medically and physically vulnerable. It's, in my view, pretty reasonable to require that that individual, that employee, be vaccinated. Take the other extreme. Let's say you have a tech support worker or a sales worker who is working entirely remotely, does not have any direct physical interaction with customers, colleagues, or anyone else. They are literally working out of their home. It's going to be really hard to satisfy a court or a judge or an arbitrator that it's reasonable to require that that person be vaccinated. So those are the two extreme ends of the spectrum. And of course, most things fall somewhere in between. But that's the analysis that a court is going to go through is it reasonable to require that this person be vaccinated? And if it's not, then firing them for cause is probably not going to fly. One important thing to remember, I talked about the two different types of dismissal. Generally speaking, you can always let somebody go. Now, it's a little bit different if you're unionized, but otherwise you can generally let someone go at any time for almost any reason. One exception is human rights. So if they were not vaccinated because of a medical exemption or a religious exemption, then you've got a different analysis. But for the vast majority of employees, they can be let go at any time, but you're going to have to give them either notice or severance. So what we're talking about here is whether you can let them go without notice or severance, which means letting them go for cause. That's the analysis. And the risk if you get it wrong is that you will be on the hook not only for wrongful dismissal damages, but if you have a court or an arbitrator who feels that you acted in bad faith by, for example, not even giving them their statutory entitlements, you might be entitled to, they might be entitled to bad faith damages, punitive damages, and of course, you're going to spend a whole lot of money on legal fees. You're going to spend a whole lot of time fighting this case instead of running your business. And if you lose, you're going to be obligated to reimburse the employee for a portion of their legal fees. So there's a big risk, which is why, I think we've said it a few times, before you make any decision, it's certainly advisable to get advice from an employment lawyer, especially a decision to terminate, because this is not simple. There is no one size fits all. There is no one rule that fits all. So get proper advice before you make the decision, ideally, and not after. And last thing I want to talk about, which is more of a procedural thing, but it has come up recently, is if someone does lose their job because of refusing to be vaccinated, how do you handle the ROE? So this is more mechanical than legal, but it's an issue that came up. And interestingly, the government actually put out some information on this point, essentially saying that someone who loses their job because they refuse to be vaccinated is not eligible for employment insurance benefits. And they also include some guidance for employers on how to fill out the record of employment. So as you can see in the slide, if they refuse to attend at work due to a vaccine mandate, then you would use code E for quit or resigned, or code N for leave of absence. If they are dismissed for refusing to comply with the requirement to be vaccinated, then it's a dismissal, which is code M. And as most employers will know, Service Canada always has the right and the ability to reach out and ask more questions. So if you put a dismissal especially, I think most people know that they're very likely to call you and find out what happened. And they will be asking things like, was there a clear policy about vaccination? Were the employees clearly advised of the consequence of not being vaccinated? Was the requirement to be vaccinated reasonable? As I've talked about it at length already, And if there were any exemptions here, did the employee have a medical or religious exemption? Those are the types of things that Service Canada is going to be looking at in assessing whether this employee who lost their job is entitled to employment insurance benefits. So that's what is going to be played out over the next few years in about 10 minutes. There will certainly be more information on this, and there will be cases that will start to come out probably a few months from now. So stay tuned to our social media and we'll do our best to keep you up to date. But at this point, I'm going to pass things over to Alex Minkin, who's going to talk about other streams of COVID-19 workplace-related case law.
Thank you, Stuart. So the pandemic is creating not only novel issues for employees and employers, but also for the courts. And in many of these issues, the courts are ruling in different ways, and in some instances, even making contradictory rulings. So I'm going to be talking about three major streams of case law in which the courts are ruling on these novel employment law issues that relate to the pandemic. So the first one of those issues that I'll be talking about is whether or not IDEL counts as constructive dismissal. So IDEL was a topic that Nadia spoke about before, and it was a regulation that was put in place by the Ontario government in response to the pandemic. The full name is the Infectious Disease Emergency Leave. And IDEL does a lot of things, but one of the things that it does is to say that a temporary reduction or elimination of an employee's hours of work by the employer for reasons related to the pandemic does not constitute constructive dismissal if it occurs during the COVID-19 period. And that COVID-19 period, it started March 1st, 2020. For now, it's set to end in the end of July 2022, but it has been extended many times before, and it could be extended again in the future. So IDEL certainly applies to constructive dismissal under the ESA. That's not a question, but it is an open question what IDEL's impact is on constructive dismissal under the common law. So we have sometimes things can be permitted under the ESA, under the Employment Standards Act, that aren't permitted under common law. And this could be one of those issues. So if we turn to the next slide, we'll see the three cases in which the court has dealt with this issue. So Coutinho was the first case to be decided on this subject. In this case, the employee said that she was dismissed, and the employer said she wasn't dismissed, she was placed on IDEL leave. The court said that this was actually constructive dismissal in common law, and that the IDEL regulation didn't have an impact on that. So the employee in that case was owed essentially the same damages under common law that they would have been if they were simply dismissed from their employment. And part of what informed the court's ruling on that is Section 8 of the Employment Standards Act, which says that no civil remedy of an employee against his or her employer is affected by the Employment Standards Act. So the court was essentially saying, since IDEL is a regulation under the Employment Standards Act, the Employment Standards Act says that the act doesn't affect any civil remedy, then there's no way that this regulation could impact the employee's rights under common law. Now, the next case to deal with this was Taylor. And in the Taylor case, Tim Hortons was the employer. They put the employee essentially on IDEL leave. And the employee sued, saying that they were constructively dismissed. The court actually in that case found the opposite. So it was a completely contradictory decision from Coutinho. And the court found that the impact of the regulation was that when an employee is placed on leave under IDEL, as long as it fulfills all the requirements of IDEL, that is not constructive dismissal under common law. And the court actually went into great detail about why, and even talked about the Coutinho case and why they didn't agree with that decision. And in that case, the court found that Section 8 of the Employment Standards Act doesn't mean what the court said it did in Coutinho. So I understand that the Taylor decision is being heard by the Court of Appeal in April. And if and when we get a decision on that, we'll have a lot more guidance on that issue. Now, the third case to deal with this is Fogelman. The employee in that case was placed on a temporary layoff as a consequence of the downturn of its business resulting from the COVID-19 pandemic. And in that case, similar to the Coutinho case, the court found that this does constitute constructive dismissal under common law, in spite of the IDEL regulation. Now, there wasn't a lot of discussion in that court case. We got that decision after the Taylor decision, But the date of the decision was actually before the Taylor decision. So in those last two cases, there's no discussion of the other case and why it doesn't apply. So essentially, we have two cases saying it is constructive dismissal, one case saying it's not constructive dismissal. And if and when the Court of Appeal or a higher court weighs in on this, we'll have more guidance on that issue. The second issue, the second stream of case law that I'm going to be talking about is the impact of the pandemic on reasonable notice. So in general, a dismissed employee is entitled to reasonable notice of termination at common law unless there's an enforceable contract that limits these entitlements. And the court looks at a variety of factors in determining what the reasonable notice period is. And one of those factors is the availability of comparable employment. So what we're seeing a lot of is employees saying, I can't get a job, or it's taking me a lot longer to get a new job as a result of the COVID-19 pandemic. And what employees are often saying is the common law notice period should be longer as a result. So how does the court deal with that? Well, in the case of Yee and Hudson's Bay Company, this was a case in which the dismissal actually happened before the pandemic. The notice period went into the pandemic, but the court said that the pandemic has no impact on the reasonable notice period. In the second case of Kraft, this was a dismissal that happened in mid-March 2020, and the court found that the pandemic, in fact, did impact the employee's ability to find a new job, and that is a factor that can be looked at to increase the common law notice period. And then the last case that I'm going to talk about on this issue is Iriotakis, where the court said they don't know. The court said that it was speculative, highly speculative and uncertain as to the degree and duration at the time of dismissal. So the court essentially said it's not necessarily a factor that's going to increase the common law notice period. And the last issue that I'll talk about is whether or not CWLB payments should be deducted from wrongful dismissal damages as mitigation income. So there are two cases, Iriotakis and Fogelman, which we both talked about those cases before, in which the court said no. CWLB payments don't count as mitigation income, so whatever you earn on CWLB shouldn't be deducted from wrongful dismissal damages. And then there's two cases, Hogan and Livshin, where the court said the opposite, said that they actually should be. So in the first two cases, the court was distinguishing CWLB from EI payments, basically saying you're not paying into, neither the employee or the employer is paying into CWLB. It's not insurance in the same way, so it shouldn't be deducted. But in the last two cases, in Hogan and Livshin, the court basically said, look, this is income that you're only receiving as a result of the termination. So if we're trying to put the employee in the same position they would have been if they weren't dismissed, we have to look at the CWLB income as mitigation income. So for all three of these issues that we talked about, there is clearly conflicting decisions. Clearly, the courts don't know exactly how they're supposed to deal with it. We do expect there's going to be more court decisions on all three of these issues, including potentially Court of Appeal decisions or Supreme Court of Canada decisions. And once that happens, we'll have a lot more guidance about how the court is going to deal with these issues in the future. So with that, I'm going to send it back to Stuart for some final comments.
Great. Thank you, Alex. I know that was a lot to cover in a few minutes, but the bottom line, you didn't say it, but I will. It depends. I mean, it depends on the facts. It also depends on the judge. Because as you made it very clear, we have the same issue considered by several judges and with often very conflicting results. And my favorite comment that I saw, I've been trying to keep up to date on the comments, thank you, Karen, for confirming it depends, was that it's, I think this was sarcastic when someone posted it's nice and clear for employers. And this is the challenge we are all going through. So we've got a few minutes left. We've tried to answer quite a few questions in the Q&A box itself, but there was one that I noticed I'm happy to kind of jump on, and then Brittany, I don't know if anybody else had anything else they wanted to mention briefly. One of the questions I saw related to a suggestion that there may have been a situation where somebody was let go, given their severance pay, but then somebody else was hired and put in that position, and couldn't the first employee then sue for wrongful dismissal? And the simple answer is probably not. And I think one fundamental thing to remember is that in Canada, most employees do not have job security. So as I said a few moments ago, most employees, and again, unionized workers are different, but otherwise, most employees can be let go at any time for almost any reason, as long as they're given their notice or the severance. And then if you do that, you can bring in someone else the next day. And as we often joke, I mean, you can do it for no reason, you can do it for any reason. You could do it because they wore a blue shirt to work that day, and you decide you're going to let anybody go who wears a blue shirt. That may not be good HR, but it's not unlawful. And especially in the context of vaccines, you might decide you are going to let anyone go who chooses not to be vaccinated. Unless there's a medical or a religious exemption there, you are entitled to do that. The only question, as I said before, is do you have just cause? In which case you don't owe them anything, or do you have to give them notice or severance? And the corollary to that, which I'll just comment on really briefly, for hiring purposes, there is, generally speaking, nothing wrong with requiring that candidates be vaccinated before they'll be hired. Again, if they're entitled to human rights accommodation because it's a medical or religious reason that they're not vaccinated, that's different. But otherwise, in some ways, it's a lot easier to not hire someone because they're not vaccinated than it would be to let them go. Because if you let them go, you may be on the hook for severance. So I know we've got a couple of minutes. I don't know if we had any particular question that anybody wanted to address.
Yeah, Stuart, I would like to address two questions which are kind of similar. The questions are, would the type of job have an impact on common law, i.e. a job that would still be in demand during the pandemic, versus one that is like a restaurant worker? And then there was another similar question about reasonable notice with the job market being so great in Toronto. So for example, in the past is so good. So as we always dependent on a variety of factors, one of the factors in assessing an employee's common law entitlements upon termination is the availability of comparable. It is a role that the employee is looking for in the job market in that geographic area. It doesn't necessarily mean it's now going to be half the notice period it would be previously, but it will have an impact.
Sorry, Nadia, you were breaking up a little bit there, but was there another question you wanted to answer, or did you cover two?
No, so I covered both the questions.
Okay, great.
Can you hear me?
Yeah, it's a little bit jumpy, but I did hear you. So thanks for covering those two things. And I think we're at 12:59 now, so I think we will wrap things up. So I do want to thank everyone. We are well over 200 attendees, which is awesome for the first webinar that we've put on ourselves. So thank you guys all for joining. And as I mentioned before, the recording is going to be available online within the next day or so. And slide deck will also be available, so feel free to reach out to us. I can send us a quick email at info@rudnerlaw.ca to ask for the slide deck. And if you do have questions we didn't get to, or if you need some legal advice, please reach out. I mean, one thing we often say is that most of our work is because people didn't get legal advice before they made decisions. So ideally, reach out before you make a decision and let us give you the advice you need. If it's too late, obviously, we're more than happy to help you, minimize the damage of any decision you've made as well. So one way or the other, we'd be more than happy to talk to you about how we might be able to help. And if we can't help, there's obviously no harm done. I do want to thank Brittany, Nadia, Alex, and Jeff for doing a great job and helping to keep us on track today and covering a whole lot of information in an hour. And I'm just looking at my notes. I don't think there was anything else I was going to mention other than, as a bunch of us have said, keep on top of our social media, sign up for our newsletter to get our employment law updates, and keep an eye on our COVID-19 resource page on our website, because this is still going to be an evolving story on many different fronts. So make sure to keep up to date. And again, reach out if you have any questions. That's all I had to say. So thank you very much for tuning in. Take care and stay safe.